If you pass away owning a vehicle, owning a car, is it going to have to go through court in order to get it to the people that you want it to get to, your beneficiaries? My name is Michael Pevney. I am an estate planning lawyer and I create estate plans for California families. Follow me for more estate planning information. I've got over 1,000 videos out there. A lot of your estate planning questions are going to be answered in that video. And if you live in California and it's time to set up an estate plan, you can set up a time to meet with me for free to discuss that. The link will be in the description and my profile. So one of the most common questions that I get when it comes to estate planning is what happens to my car? What happens to my vehicle when I pass away, whatever car that I own? I'm going to give you a couple of different scenarios. The first, what happens when I either have a will or no estate plan at all? And then what happens if I have a trust set up? And I do set up for most of my clients in California that either own real estate or they have little kids or people that depend on them. I do set up living trusts as sort of the central estate planning document. So now the overarching rule is generally as long as assets that would have to go through court, that would have to go through probate, if they're less than $208,000, and this is for the year 2025, a vehicle does not have to go through probate, even if you do not have any sort of estate plan set up, or if the main estate planning document you have is a will. So cars can be passed along in a couple of different ways. First, if it is jointly owned by more than one person and the other joint owner is alive, when you pass away, that ownership simply goes to the other owner. Second, if that car is in somebody's name and they're probatable assets, meaning things that are subject to probate, meaning there is no pay on death beneficiary or there are no beneficiaries on life insurance policies or retirement accounts or anything like that, those non-probatable assets are under the amount of about $208,000. That vehicle is not going to have to go through probate. We have to essentially sign an affidavit, present a death certificate to the DMV, the exciting Department of Motor Vehicles in California. And yes, somebody's going to have to stand in line in order to do this. What are the drawbacks to this? First, if a car is going to pass by way of joint ownership, then both owners of the car could be liable for any accident, any car crash that the owner of the car gets in, or even the co-owner of the car that wasn't responsible for the crash. So we do want some liability protection there. Here's a quick pro tip for people that have kids and that own a car that belongs to their child. If and when that child turns 18 years old, might be a good idea to title that car in the name of that child. An 18, 19-year-old, usually they don't have a huge amount of assets, and you don't want to be on the hook and have your home and your property on the hook for a crash that involves that child. Because if they don't have a huge amount of assets, well, frankly, people don't sue people that don't have assets. Always we want good insurance in place. And so that's generally what happens if we don't have a trust. If we either have a will or we have no estate plan and those probatable assets go up to and is under $208,000 or so. If we're above that amount, we're going to have a full probate. It's going to cost a bunch of money. It's going to have to end up going through court. It's going to be a lot of stress and a year and a half to 2 years to even just get that vehicle through the probate system along with the other assets, whether that's financial accounts, real estate, things like that. In my practice, what I do for most of my clients is I set up a trust, a revocable living trust that says where you want your stuff to go when you pass away in a way that avoids the probate process. It's going to save the average California homeowner about $50,000 and save the ones that they leave behind about a year and a half to 2 years stuck in court. Now, how do vehicles sort of intertwine with and get put into a trust, or do we even want to put it into a trust at all? So here are the good things about putting a vehicle in a trust. And when I say put it in a trust, I mean actually going to the DMV, having things retitled. If you buy a new car saying, I have a trust, I want it titled in the name of the trust. There's going to be no question about whether or not the car is now in the trust because it is officially titled in the name of the trust. The drawback to that is, and this is going to be a little bit of a liability issue, if you get into a crash, if you are driving the car and you exchange information and it turns out that, you know what, this vehicle is actually owned by a trust, there's a possibility that the other person that was involved in the crash might think that your pockets are a little bit deeper than they actually are. Now, you don't have to have a huge amount of assets to set up a trust. Certainly any homeowner in California, we do want to set up a trust for anybody that has kids under the age of around 30 or so, or you care for anybody that doesn't have a huge level of responsibility with money, a substance abuse issue, anybody with special needs, then we're going to want to look at a trust for that main estate planning document. Now, there is another way a vehicle inside of a trust without actually having it specifically titled in the name of the trust by going to the DMV to do that. And this is typically what I recommend for most of my clients. We have a specific document, and that is either in an addendum to the trust itself where we name a specific vehicle or any and all vehicles owned by the people that set up the trust at the time of setting up the trust, or we set up a different document called an assignment of personal property. And that includes, and we specifically say this assignment of personal property includes all vehicles owned by me at the time that we set up the trust or that I purchase after the trust is created. I am specifically assigning those vehicles to the trust. That should put the vehicle inside of the trust without having to actually change the title. Saves a little bit of a headache of having to go through the DMV, but this is something that's important to do. And then when you pass away, whoever the beneficiary is should be able to take that trust or take that document to the DMV along with a death certificate showing that the owner of this car has passed away and they intended to put it in the trust. And in fact, they did. It's one of these things where sort of with the stroke of a pen, things go inside of the trust. This assignment of personal property also includes other assets like jewelry, clothing, electronics, antiques, keepsakes, collectibles, the old baseball card collection that your grandma thankfully didn't throw out because there's a Mickey Mantle rookie in there. That's actually happened to me before. So generally, if we have a trust, I'm going to recommend to many of my clients that we do not actually change the titling of the vehicle at the DMV to the trust, but we always sign this assignment of assets and assignment of personal property, which specifically includes vehicles. This has a few benefits. First, nobody has to go to the DMV to actually physically change the title. Second, you don't necessarily have to alert your insurance company. There are horror stories out there when people transfer their car with the DMV into the trust, they get into a crash, the car was not added or the trust was not added as an additional insured to the policy, and there is an issue with coverage. And then finally, third, there is that liability issue where there is nobody can see that the car is owned by the trust because we didn't necessarily change that title. So that is a brief overview about how we handle vehicles as part of an estate plan. It's a little bit different depending on if there is a trust set up or not. And if there is not a trust set up, it depends on the value of the assets, including the value of those vehicles. If we can keep that under $208,000 and we can fortunately, things that do not have to go through probate are things that have a beneficiary listed or a TOD or POD beneficiary. If there are bank accounts, that does not count towards that $208,000. This is the 2025 limit. And then we have a slightly different way that we handle things if there is a trust set up. For most of my clients, not all, sometimes there is a very special collectible vehicle, very valuable vehicle, race car, something like that, that we specifically maybe do want to title in the name of the trust. If we do that, always important to notify any insurance company, car insurance company, and add the trust as an additional insured. Usually not a huge problem, but many of my clients, we sign this document, this assignment of personal property, placing all vehicles in the name of the trust without having to go down to the DMV, stand in line, show them the trust, make sure things are titled in the name of the trust, and then notify the insurance company. Not completely necessary in every circumstance. So that's a brief overview of how we handle vehicles as part of an estate plan. Oh, and by the way, very small chance that you are going to be driving the same vehicle that you own right now when you pass away. And an assignment of any vehicle should include any vehicles that you don't own yet, that are not purchased at the time of the creation of the trust. So once again, my name is Michael Pevney. I create estate plans for California families. If you have any questions about this, trusts, probate, anything else, ask it in the comments section. I'm very likely to give some sort of a reply. Sometimes the reply might even be by video. And if it's time to set up that estate plan, you can go to my website, ocestateplanlawyer.com, or find the link in the comments or the description, or my profile on whatever platform you are watching this on. Thank you for your time, and thank you for your attention.